Hi, I'm Tom Swigel.
I'm Nitin. Nice to meet you.
Nice to meet you.
From the DOJ, yeah?
Yes,
Great. What order are you in the lineup?
I think I'm last.
You last? Okay,
Uh-huh.
that's great.
Are there 4 of us or 3 of us?
I think he said there are 4 of us. But maybe one of us has,
Pulled out.
yeah. I think I may have misjudged the nature of the audience based on the first couple of talks, so I've got to make some adjustments.
Tom, Will Pomerantz.
Hi,
See you.
nice to meet you.
Okay. So I think
Do we have 3 or just 4?
we're
4
going
or
to just have 3.
Okay.
Shelley has unfortunately dropped. So, 15 minutes still though, because I think we're the
Sure.
panel that stands before lunch.
Yes.
Yeah.
So there will be a revolt, I'm sure, that if we don't move it along, and we might go over 5 minutes or so, but the idea would be to keep it going.
That's fine.
Yes. The webcast needs to know when lunch is too. Okay. If everyone could take their seats, I think we're going to get going here. Is everyone? Should we get started? Okay. Well, welcome to the 3rd session on rule of law and resource depletion. I think we're going to be following on a lot of the points that were raised in the first panel. And with us, we have 3 very distinguished speakers, Daniel Schleifer, Nitin Sikar, and Thomas Wagle. You have their bios in your collected information, so I will just give very brief introductions as we get started. And we're going to begin with Daniel Schleifer, who is the Senior Officer for Technology and Enforcement for the Pew Charitable Trust's Ending Illegal Fishing Project. He brings a long career with the U.S. Coast Guard and a distinguished background to this discussion. So, Daniel,
Thank
the
you.
floor is yours.
Thank you. Thank you very much for having me here. I appreciate the opportunity. It's not often that in my previous role I had an opportunity to talk to the public about fisheries enforcement. It's something that's been a passion of mine for the 27 years I was in the Coast Guard and continues on with my work with Pew Trusts. Based on my opportunity to do all those things I never had a chance or resources to do, now I have the opportunity and obligation to do so. So I appreciate the chance to talk to you. The first thing I want to say is just a phrase that comes from somebody in the past that really speaks to what I want to address today, which is transparency breeds self-correcting behavior. And I'll get back to that as we speak to other issues. So in 2018, coming up, is marked the 25th anniversary, if you will, of the pivotal international fisheries guiding document, if you will, the UN Fish Stocks Agreement, as well as other agreements that the UN and world community put together back in the early 90s, all with the intent of addressing the problem of illegal fishing on a global scale. 25 years later, we're still having the same conversations. We're still talking about the same problems. Nothing seems to have really moved, but yet here we are again with the world's attention focused on illegal, unregulated, unreported fishing. But what have we done to help address the issue? Well, we've put in place guidelines. We've put in place doctrine. We've helped places put together rules, laws, regulations, but yet the problem still persists. And why is that? Well, part of it is at two levels. First, the domestic, I'll talk to that, and a little bit on the international level. Put a caveat on what I'm talking about today, though, is I do not want to get into, for sake of time, artisanal fishing or small-scale fisheries. My remarks are generally focused on the large-scale or industrial fishing, particularly that in the high seas and beyond the EEZs. So at the domestic level, why do government officials or governments as a whole fail to act to curb illegal fishing? We talked a little bit today from other groups about corruption. That is certainly an issue. But I also think from my experience in many of the different parts of the world that I've been to, that it's also a lack of integration and knowledge throughout the agencies within the government of what rules, laws, and adjudication procedures are. So I'll give you some examples as I go along. West African nation in 2009 had an opportunity to engage with them on a fisheries enforcement operation, if you will, through Africa Partnership Station. We found illegal fishing vessels from a foreign nation fishing within the waters of this nation. We had enforcement officials from those nations on board to allow us to take action. They took jurisdiction, sort of, brought it into the pier, and we thought things were fine. That means they found an illegal boat, they brought it into the pier, they prosecuted, things were great. Not the case. We found out that they had no idea who had authority or jurisdiction to conduct the boarding in the first place. Was it the fisheries folks? Was it the National Police? Maybe it was the Navy. Or was it somebody else? They had to work that out. It was not the fisheries folks, as a matter of fact. They had the ability to board, but they have no ability to take enforcement action or seize the vessel. That was the National Police. Who was going to prosecute it? Well, National Police had no idea how to put together a case package to help adjudication proceedings, the judicial proceedings to proceed. So they had no idea what they were doing as far as that goes. And once it got into adjudication proceedings, it kind of went into a black hole. And within 2 days of that boat getting into the pier, it was headed out to sea again. Something wasn't right there. Actually, a lot of things weren't right there. And we found out through our discussions with the Ministry of Foreign Affairs, the Ministry of Justice, and even the press, how much information was lacking across the agencies to do anything as simple as seize a vessel for operating illegal in their EEZ. It wasn't that simple. Well, it turns out that the public got a hold of it first. It was published in the papers because it was an operation with the U.S. government and their government. It resulted in a seizure of a Chinese vessel. So the first thing happened was the public said, we want to know what happened here. So they're knocking on the door of the President's office, the Ministry of Justice, so why is this boat leaving the harbor if it broke our laws? All of a sudden, the boat's headed back into the harbor and is being reassessed another fine. People are putting through the adjudication procedures again. Turned out there was a little bit of money change of hands that nobody was aware of, but the transparency of bringing it to the public light that there was an illegal action that took place and government that was supposed to take actions didn't take it, forced that particular episode to come to light, to the point where the Ministry of Justice was in the front of the President's office having to defend himself as to why it happened. Pretty much lost his job after that. But didn't stop there. When they were trying to adjudicate this vessel, they did not have, someone talked about this before, they did not have judicial proceedings in place to even prosecute for a fisheries violation. They had never done it before. They were based on colonial laws that were written several decades before that, and had never even practiced it or hadn't proceeded to prosecute anybody for this violation. So we had to go through, with assistance from legal centers, and develop on the spot legal proceedings for them, give them training on how to adjudicate the case, and help them go through that process. And even then, it ended up in a prosecution that was not quite in line with normal international norms, particularly Article 73 of UNCLOS, that says you're not supposed to imprison people strictly for fisheries violations without agreement otherwise. But they did. They put people in jail for 4 years, fined them several $1 million, the whole bit. So that's an example of where in one country, and this is just one in many, that we found the same issue, where cross agencies aren't even talking to each other. There is no transparency cross agencies or with what the public is seeing that the governments are doing. But when you resolve those issues, the end result was the next case we had, the next 3 years of cases we had very similar to that in that country, resulted in proper procedures, aborting, inspecting, seizing, and adjudicating those cases. So it can be overcome, but it needs to be clear that transparency is not just about the public knowing what's going on, it's also about the government agencies across the board knowing what they're doing. So they need laws that they can enforce, they need laws they can understand, and lawmakers need to understand what rules and laws they need to put in place in order to facilitate the enforcement actions in the first place. That's on a local level. But even if all these things go right, there are other issues involved with adjudication. One of the hidden things that people do not seek or see unless you're part of the process is the actual costs of adjudication, which does act as a deterrent for many countries to take effective enforcement action on these vessels that they find fishing illegally in their EEZs. One example, even within the United States government side, there was a vessel called the Bangang Perkasa stateless vessel that we seized in the high seas North Pacific for a violation of high sea net moratorium. By the time the adjudications were done in the U.S., it was 2 years later, almost $2.5 million of costs associated with this vessel. And yet, what did the government get out of this? Nothing. We had to scrap the vessel, cost us $2.5 million to that end. And even within our own agencies that had to pay for that, it was the Coast Guard and NOAA, there were issues coming up with the funds to pay that bill. So that certainly acts as a deterrent. It's not just the U.S., though. In the South Pacific, Palau had a vessel from the Philippines they caught. Several months later, $850,000 in costs to maintain the vessel and port fees, feeding the folks, housing them, the whole bit. They finally adjudicated the case with the Philippines. And the same thing happened in other South Pacific nations and several West African nations, where the costs of maintaining that vessel and adjudicating it far exceeded the benefit to which they were going to achieve. So, of course, that does act as a deterrent to want to take enforcement action of traditional sense. So what are we left with? Well, there's alternatives to enforcement. People use the word enforcement, and the first thing that comes to mind is boots on deck. An aircraft or a cutter finding somebody, boarding the vessel, dragging it back to the pier, running it through adjudication procedures within that country, and there you go. Well, I'm going to propose to you there are alternatives to what enforcement should mean, and we should expand our definition and understanding of the term enforcement. Enforcement is, in general, getting someone to do something or not to do something that you don't want them to do. Right? They have a behavior you don't want to have happen, so you want consequences to keep them from happening in the first place. One of the things that's happening on the international level is the realization that international frameworks that are already in place are very effective at achieving that compliance for illegal fishing, at least on the high seas and large scale. A couple examples of that include the EU regulation on IUU, which results in countries potentially being yellow and or red carded for activities of their citizens or their vessels or them not taking sufficient actions to prevent them from conducting IUU fishing. Two examples where it was very effective is Korea and now Thailand, two countries that were yellow carded for their inability to control their IUU activity of their nationals. Korea, in response to the yellow carding to prevent themselves from being red carded, which would prevent them from importing into the European market their seafood products, went through extensive measures to reform their fisheries laws. I believe, and I've got the numbers right, but 24 to 25 out of 27 provisions of their fisheries laws were reformed, including a new tracking center, new regulations on prohibition of their citizens supporting IUU, whether they directly do it or not, and other things that have gone a long way toward correcting the problem of IUU for any vessel flagged or owned or linked to Korean citizens. Thailand's going through similar issues right now with the yellow card with the EU of trying to correct deficiencies in their IUU laws and their local fisheries laws as well as others to get in compliance with the EU to prevent them from being subjected to a red card or prohibiting them from importing into the European market. So those are market measures, costs, that are potentially impact of the nation, not just the citizens and not just the vessels, that have resulted in changes of behavior, have resulted in changes to how operations are to prevent illegal fishing on the high seas. The other more recent one, if you're following fisheries regulations, port state control measures, was adopted by the UN COFI several years ago and is on its way toward implementation. Needs 25 countries to ratify for it to come into force. The U.S. was one of them recently, within the last month. First treaty in 10 years we've actually signed, so that's a bonus on the fishery side of things. But before it's even in place, there are several places around the world that are already taking the concept, the idea of port state measures, and applying them and showing the success of what this can do. Again, it's a market-based measure. It's a way of providing or implementing economic sanctions or economic consequences to illegal behavior of fishing vessels. And the example I'll give is in Africa again. We had Sierra Leone document a vessel repeatedly violating its EEZ fisheries. As a Korean flag vessel called the Premier. And before it could be caught and adjudicated in court, it ran off, took off. And it was being tracked through a project that we have, and we watched it go around the other side of Africa and was trying to land in one of the ports in Eastern Africa. Sierra Leone had a partnership with the countries in East Africa that agreed that they would not let this thing into port. Similar to port control measures, it says if it's involved in IU fishing, do not let it into your port. It can't refuel, can't reprovision, can't restock. You do not come into port, you're denied entry. So they all agreed to this. So the Korean vessel tried several ports in the east part of Africa, were all denied. So it's out there in the Indian Ocean bobbing around with several $1 million of product and nowhere to land it. And in long story made short on this one, the owners finally came to the table and paid a several $1 million fine owed to Sierra Leone before they were allowed to land that product. And even then, that product was then tainted and they've had a hard time finding a market to sell it. So again, an economic sanction based on an international framework without actually having to go through the expensive procedures of adjudication of a foreign vessel. So there are alternatives out there, and that's what I suspect and suggest we look at is the definition, enforcement, and change. So conscious of the time, I want to keep it short and end my remarks there. Thank you.
Thank you very much, Daniel, for setting such a good example. We're going to turn over to Nitin Sikar.
Sure,
who
and
is
move
a-
up front. That's okay.
Okay, who is an ecologist and conservation scientist working with the Forestry and Biodiversity Office at USAID. Floor is yours.
Thanks. Got it. Okay. Well, thanks everyone very much for having me. My name is Nitin Sekar. This is my first time to the Wilson Center, and I'm definitely honored to be here. I'm actually here to represent the basic argument underlying USAID's approach to rule of law and biodiversity conservation. And so I think during this part of the presentation, I'll outline some of those basic arguments to you. And while I'm talking, I'll also point out the specific areas where I have more personal expertise, which we can maybe discuss during the Q&A. So I want to basically outline, or I want to describe three objectives in this talk. So I want to describe the multiple objectives that rule of law must serve in order to be legitimate and effective in conserving resources. I want to outline what USAID and our partners are doing to establish a rule of law that meets those objectives. But the very first thing I want to do is convey just how big the stakes are in our efforts to address resource depletion problems. When I tell people that I work for the Office of Forestry and Biodiversity, one of the first reactions I get is, why does USAID, a development agency, have a Forestry and Biodiversity Office? And the reason is that forests, fisheries, and other natural capital are resources that, if managed well, can help promote development objectives, and if squandered, can really impede development. So let's take forests to begin. A study led by Mark Imhoff at NASA found that humanity uses about 4.3 petagrams of carbon, mostly from wood, for fuel each year, and that's more than the biomass used by humanity for food. In 1998, developing countries earned $10 billion by selling timber to global consumers, which means that appropriate taxation of those resources could generate important funds for those countries. And while not everyone who lives in forests are poor, the majority of the 240 million people living in forests are quite poor. And for them, how this resource is utilized and who profits from it matters a lot. So next, let's talk about fisheries. Fisheries are a major source of employment and food. One estimate suggests that over 260 million people catch fish as part or the full part of their livelihood. And for many of these small-scale fishers, losing that resource could be kind of devastating for their economic well-being. The Food and Agriculture Organization says that over 1 billion people are using fish as their primary source of animal protein right now. So depletion in that resource affects them directly as well. And finally, I think this is a maybe less appreciated example. Consider just the tourism benefits of wildlife. A recent study estimated that about $600 billion is spent on access to and services in, so direct expenditures, in terrestrial protected areas worldwide. 80% of those visits are happening in Europe and North America, which, as you may know, doesn't necessarily have the most diverse wildlife to offer to tourists. Even though the potential of wildlife tourism in the global south is under-realized, some countries are quite dependent already. In 2008, the tourism industry produced 15% of Tanzania's GDP. So you can then imagine the tremendous economic opportunity for low-income communities living in remote areas with high biodiversity as the growing middle class globally begins traveling around the world. It should be said that a lot of money is also to be made through unsustainable exploitation of this resource. The NGO Traffic estimates that the illegal wildlife trade for land-based species is worth about $10 billion a year. This includes items such as ivory and rhino horn. And on top of all of this, wildlife provides ecosystem services such as pollination of crops, new pharmaceuticals, non-timber forest products, mushrooms and bushmeat and so forth, that at the global level are worth perhaps trillions of dollars, but for local communities are just a part of surviving on a day-to-day basis. So those are the stakes. And since natural resources are form such a key growth opportunity for the poor, we need strong governance structures, like the maintenance of rule of law, to manage them. The law gains legitimacy and thus becomes enforceable if it balances and serves two fairly distinct objectives. The first and obvious one is sustainability. Many of us in this room, when we think about natural resources, often think about making sure that they're available for our children or grandchildren, the posterity argument. So we want governments to uphold a rule of law that, for instance, prevents overfishing around the world, such that, like the example given by my co-speaker. So about 32% of the world's fisheries are currently overexploited or depleted, and that threatens both biodiversity as well as the possibility of having an adequate source of protein in the future. But rule of law should also be used to ensure that resources that are exploited are fairly distributed. Take, for instance, the case of Senegal, which is unable to prevent trawlers from Russia, Korea, and other countries from illegally catching fish off its coast. Though things have improved now, a couple of years ago, Senegal was losing $312 million a year that it should have been getting in tax revenue, which amounts to about 2% of its GDP. And this is a problem faced by many poor countries. And conservation laws have also been used to, conservation laws that are supposed to serve sustainability and conservation objectives also often are enforced at the direct expense of indigenous people. The most extreme example of this is forced relocation for conservation. When Yellowstone National Park was formed, the Eastern Shoshone Native Americans were forced out. Several Black African communities were forced out of South Africa's Kruger National Park, which then became a recreational space for white South Africans. Overall, though it's very difficult to calculate this, researchers estimate that some 8.5 million people, mostly low-income and disempowered, have been displaced in the name of mostly legal wildlife conservation. Most frequently, such populations lose their livelihoods and become destitute as a result of this dislocation. And it's not only a problem that's happened long ago. Over the last several decades in Uganda, the Bathwa ethnic group, who are also known as Pygmies, was not only expelled from Windy National Park to help protect gorillas and the appearance of naturalness in the reserve, but they were denied development opportunities because European tourists enjoyed seeing the Bathwa in their quote-unquote natural state. In part because they no longer had access to their natural resources, they were not allowed to practice as hunter-gatherers. Many Bathwas were forced to begin performing songs and dances for white tourists, and incidentally, they didn't have their own song and dance that was appealing to white tourists, so they had to take it on from a different ethnic group. So given this history of conservation, the challenge is to develop laws that promote sustainability and that are socially just. and then to use the legitimacy of such law to help build rule of law. So such laws should have basically three attributes. First, they should ensure that the poor have opportunities to realize their own socioeconomic aspirations. Secondly, such laws should help conserve culturally and economically valuable species and ecosystem services. And finally, where conservation and development conflict, there should be mechanisms that protect the poor from becoming further marginalized. So actually accomplishing these objectives is easier said than done. And USAID is trying to explore actual mechanisms and tools and policies and approaches that can help us succeed. I would encourage you to look at the USAID's new biodiversity policy, which came out a couple of years ago, and our biodiversity and development handbook. And I think these documents do a good job of going in more depth as far as what kind of approaches our organization is taking to achieve these objectives. But I will go through just a couple of examples, and I think these are concepts all of you are very familiar with. Maybe the examples will be somewhat novel. So one of the things that we are trying to do better is actually engage local stakeholders more in a more meaningful way. With, again, the idea that conservation policies become more legitimate and thus more enforceable if implementers involve local stakeholders in all levels of decision making. So one of the successes in the conservation world is Nepal, at least the more mountainous regions of the area of the country. Nepal is often celebrated as a place where there has been a record low level of poaching of tigers and rhinos and an improvement in the sustainable use of forests over the last several years. What has happened is that the Nepalese government has largely devolved forest management responsibilities to local community forest user groups. So these local groups are responsible for protecting the forests from illegal use, for collecting fees from those who extract natural resources, and then for investing 25% of what they collect back into forest maintenance. And the combination of these rules appears to have helped promote both local economic gain and nature conservation. In many situations, local people do not have the skills or the experience or the knowledge required to advocate for their own rights when negotiating with the state. So our handbook recommends that some NGOs should be engaged in helping advocate for local people in determining the rules that dictate resource use. So I'll actually go over an example of that in a moment. And finally, the UN Declaration on the Rights of Indigenous People promotes the requirement that indigenous communities approve any action that may affect them or their natural resource base. And this is called FPIC, Free, Prior, and Informed Consent. USAID is now considering how to implement this principle in practice. And my personal research has had to do with the relocation of communities from tiger reserves in India. So I'd be happy to talk about this during the Q&A. Okay, so in addition to involving local stakeholders, I'd say the other big piece of USAID's approach to trying to come up with sustainable and socially just conservation policies is following the evidence. And so there are two big flavors of evidence I'm going to talk about. The first is the science. And there are some really good examples of us getting this right. For instance, in Mosquitia, Honduras, community members were conducting lobster catching by scuba diving pretty deep into the ocean, which is bad for their health because they weren't trained in how to do that properly, but also led to a depletion of the populations of lobsters. And technical experts through a USAID program went there and helped figure out how much could be harvested sustainably and help come up with alternative livelihood opportunities for fishers who then had to scale back on their collection of lobsters. But it's actually quite difficult in many situations to figure out what conservation interventions actually achieve desirable ecological objectives. Measuring animal populations, plant populations is not trivial. So we can talk a little more about that later if you would like. The other big thing is, of course, making sure that we get the incentives right for communities that are at the forefront of resource depletion. So I have a few examples here. So in the 1970s in Niger, deforestation had gotten so bad that much of the country's farmland had become arid and was losing its nutrients, resulting in lower crop yields and food insecurity. In order to stop deforestation, the Niger Forest Service was given the authority to fine anyone who cut trees, even if those trees were on their own land. So villagers did the natural thing. They made sure that if they ever saw a sapling, they killed it so that they would never have to pay a fine for cutting the tree once it grew, especially if it was obstructing their agricultural practices. So basically what happened is that an NGO called Serving in Mission ultimately worked with the local authorities to get them to stop enforcing this rule verbatim. And they then explained to local villagers the benefits of agroforestry, so having some trees on their land that helped increase nitrogen levels in their soil. And they assured the villagers that they would not be punished if they allowed these trees to grow on their land. So in the last 40, 50 years, agroforestry from leguminous trees in the Zinder region of Nigeria has actually helped boost agricultural yield by 30%. So this is an example both of involving local stakeholders, but also helping NGOs bridge the gap between a very powerful and maybe not so trusted state actor and local community members that don't have all the information they necessarily need to make optimal decisions. Another problem with conservation projects is often that the payoff for good natural resource management isn't often evident for a long time, perhaps even years, making it difficult to keep communities who need resources fairly immediately engaged in conservation projects. And so one thing that the conservation community, including USAID, is starting to do is create incentive structures that allow community members to realize some benefits in the short term. Sometimes with marine protected areas, those benefits come quite quickly. Fish stocks can replenish very quickly for some species, and it becomes self-evident to communities that conservation is beneficial. But I think we're also starting to experiment with a wider array of tools. A program called Conservation Through Public Health has found that communities are more enthusiastic in Tanzania and the DRC. They're more enthusiastic to help patrol the forests and help stop poaching if they're also provided family planning and other health intervention services. And so this kind of program design helps both promote sustainability and help kind of promote our ideals of social justice and development as an organization. How are we doing with time?
You have about 3-4 minutes.
Okay, great. So another example is a project we're working on in Uganda with the African Wildlife Foundation, where we've helped introduce the production of bird's eye chili in the communities, because African elephants that trample other crops and eat other crops don't usually go after bird's eye chili. And so the community was incentivized to help with conservation objectives because they realized they're going to have access to what they needed to produce this cash crop. But it turns out that these villagers are also just incentivized by the opportunity to have a relationship with the Uganda Wildlife Authority, with state officials, because generally they don't see government officials at all. And they recognize working with any government group as an opportunity to potentially improve their development situation later on. So, of course, given how much there is to be gained by overexploiting some natural resources, particularly goods like ivory and rhino horn, carrots aren't always enough to help establish the primacy of rule of law, and so we need some sticks as well. So this is the enforcement continuum I think that Daniel was kind of talking about earlier. So USAID also works further down the continuum, not just with trying to educate communities and help them out economically, but also with the bigger sticks. So for instance, we worked with countries such as Vietnam and the DRC to strengthen the wildlife trafficking laws so that traffickers have to serve more jail time and pay higher fines if they are caught. We've trained and equipped hundreds of eco-guards in places like Central Africa to improve the on-the-ground enforcement. We've launched a wildlife crime tech challenge to develop technologies that help detect poachers in the field, because they're traveling in very remote areas, and coordinate responses by rangers. So for instance, we're trying to use heat-sensitive cameras. There's proposals that have been put forth for drones, DNA testing that can help us actually detect trafficking earlier. And finally, we are pursuing creative alliances to offset the inherent difficulties of enforcing rule of law in low-resource settings. So for instance, as you know, poaching happens across a huge space, across much of sub-Saharan Africa, South America, and Asia. And they ultimately are distributed to consumers over a large area as well. But in the middle, these illegal wildlife products have to be funneled through a relatively narrow space, which is the transport sector. So much of what's smuggled is actually put through legal supply chains. And so, and this is something the private sector transport and shipping companies don't want to have happening on their watch. So working with the NGO Traffic, USAID, and actually some other NGOs as well, we partnered with private sector partners to try and make it harder to get illegal wildlife goods through illegal transport chains, basically trying to pinch the illegal wildlife trade at the bottleneck and enforce, various aspects of rule of law in that way. So that's it.
Great.
Thanks.
Thanks so much, Nathan. Our third speaker is Thomas Wagle, who is Senior Counsel, the Law and Policy Section, Environment and Natural Resources Division, Department of Justice. Tom, the floor is yours.
Thanks, Will, and I want to thank the Rule of Law Collaborative from the University of South Carolina and the Wilson Center for inviting me to speak at this event. It's it's an honor. So you heard on the keynote speaker from John Cruden about some of the international work that the Environment and Natural Resources does, particularly our capacity building work. And I wanted to go into a little more detail about the capacity building work that we do, why we do it, and how we engage with partners from other federal agencies and from NGOs and other governments in carrying out this capacity building work and some of the benefits of it. The Environment and Natural Resources Division does not have an international unit that is comprised of personnel who work solely on international cases or on international capacity building. And only a small handful of the attorneys in the Environment Division actually even spend a majority of their time on their international work. Most of the attorneys who do this international work for ENRD are prosecutors who actually prosecute a variety of different cases, including the cases involving transnational environmental crimes like wildlife trafficking, illegal logging, illegal fishing. And we also have a small group of people in the law and policy section that I work in who work on the policy issues on international environmental issues, those same issues. And so we work together on doing this capacity building. And the reason why we do it for a couple of reasons. First of all, with these transnational environmental crimes, a first purpose is to raise the capacity of the enforcement officials in the supply side countries where the wildlife trafficking and illegal logging is actually occurring, so that as a result, they are able to attack the problem at the source through better enforcement in their own country to address the problem before it enters into the transnational supply chain. Secondly, a reason why we do it is to build relationships with those prosecutors, with our enforcement counterparts in those other countries, so that we can get to know them, build relationships, and share information with each other about the transnational flow of illegal natural resource products. And as a result of doing this type of capacity building in supply side countries, we are in fact obtaining valuable information from our law enforcement counterparts that supports investigations and enforcement in the United States. One important aspect of how we do our capacity building is we do it not solely by ourselves, but in cooperation and collaboration with other federal agencies and other partners. First of all, we receive vital support, financial support from other agencies that allows us to do this work. We don't have a specific budget that allows us to do capacity building work. We have to receive funding to do it. So the State Department Bureau of Oceans and International Environmental and Scientific Affairs has provided us with support to do Lacey Act outreach and capacity building on illegal logging work. And we've also received support from the State Department International Narcotics and Law Enforcement Affairs Bureau for wildlife trafficking work. So that's a vital source of funding that we have. In doing the capacity building work, though, we also partner with agencies in delivering our capacity building workshops and training programs. And that's an important aspect for a couple of reasons. First, in the United States, when we bring our enforcement actions, we rely on investigators from agencies such as the Fish and Wildlife Service, the National Oceanic and Atmospheric Administration, and the Department of Agriculture, Homeland Security investigations to develop the information that we get. So we work in partnership in our enforcement work in the United States. And it's vital to also bring that collaborative work to our capacity building, because it's a necessary aspect of the effective enforcement in the countries where we're doing the training. So what we have found in some of our capacity building is that when we do a course for forestry investigators and prosecutors in a country, sometimes our training is the first time where they've ever met each other, that the prosecutors actually don't know the people who are supposed to investigate forestry crimes or wildlife crimes. So we bring them together in many of our training programs so that they will work together in the course. We include sessions on investigative techniques, gathering of evidence relating to these natural resource crimes, interview techniques, issues specific to prosecuting wildlife trafficking or illegal logging cases. And we also include speakers who are experts from the countries where we're doing the training, who can talk about successful prosecutions that have been brought under the local laws, or have panels to discuss the problems that are faced in prosecuting cases under their laws, and so that they can discuss problems and potential solutions to them. We also include sessions where workshop participants break into small groups and work together to solve hypothetical scenarios about how to effectively investigate and enforce a particular scenario of illegal wildlife trafficking or illegal logging. And when we do these hypothetical scenarios, we break into groups with a mix of investigators and prosecutors so they can work together and discuss what the investigators, how they gather evidence. The prosecutors can explain what kind of evidence they'll need to be able to get it into court and prove their case. And so they can work together and start to form relationships in prosecuting cases. And we are now doing wildlife training in Africa. We just, in the fall, finished a first round of training in southern Africa. And these courses that are being funded by state INL are for prosecutors and judges. There were already training programs that were being done for investigators in the area, but there was a perceived need for training for prosecutors and judges. So we conducted a training program in Zambia for these officials from 6 southern African countries, and they, in turn, we had a curriculum designed for them, and they worked together on problem solving. So the training allowed the judges and prosecutors to work together on coming up with solutions to hypothetical crimes, could talk about how they should handle evidence in court. The judges can give advice about how best to build the case. And so it's a way to work together collaboratively on coming up with solutions to enforcement scenarios. And we plan to conduct a similar wildlife trafficking training course in Ghana later this year for judges and prosecutors from West African countries. Another type of collaboration that we have found to be effective is cross-border training with officials from within a region, from across different countries. For example, for several years, we have been doing illegal logging training in Peru and in Brazil separately for investigative police and forestry officials, and the same and prosecutors, and the same officials from Brazil. But we were not working together. But the Peruvians noted that that a lot of the illegal logging products that leave their country do so on the Amazon and go into Brazil. So there was a desire for a cross-border training, and we brought together last June a group of about 100 investigators and prosecutors from the 2 countries, meeting in Lima, to do both capacity building training and also discussion of cross-border issues and how they can work together across the border to share information so that they can do enforcement actions on this cross-border trafficking. And they've pledged to work together in the future on attacking the illegal logging program. And in an upcoming illegal logging enforcement training that we're going to do in the Congo Basin, we plan to include a number of Congo Basin countries and do the training in the port of Douala in Cameroon, which is an important port where much of the forest products from the region, including illegal forest products, leave the Congo Basin for overseas export. And we hope to discuss with the officials from these countries how they can work together on the flow of illegal timber through the region. Now, to prepare for the workshops that we conduct, an important aspect of it is the preparation for them, and non-governmental organizations that work in the countries where we do training have been vital partners. We interview them, gather information from them about what the conditions are in their country, what are types of illegal logging issues that they're facing, how is the law violated, what are corruption issues in their country, and also what are the relevant agencies that we should invite to our training programs, and if they have recommendations for particular individuals who seem particularly interested in pursuing these types of natural resource cases, we try to invite them. So getting information from these partners is really important. We also, prior to the training, try to meet with government officials from the countries where we're doing our training to get their buy-in. It's probably among you people who have done capacity building training, one of the most dispiriting things to happen is when you do a training program and the people who show up are middle level or upper level government officials who don't do anything about enforcement, and they're very happy to get the per diem every day. But they're not going to do capacity building. They're not going to do enforcement actions. So you try to do some groundwork ahead of time to try to get the right type of officials to come to your training, people who are actually going to bring enforcement actions afterwards to use the skills that they develop in the course. And we've also started partnering with other entities to do our capacity building, and that's been very valuable. For example, in the wildlife trafficking training that we have done in Southern Africa and will be doing in West Africa, and also our Congo Basin training, we have partnered with the UN Office of Drugs and Crime, which is increasingly focusing on environmental crimes and has developed training curricula on issues like money laundering in the environmental crimes sphere and corruption, how to deal with corruption issues. And they have strong expertise on that, and they are able to add some of their own resources to our training. So they've been really beneficial partners for the work that we've done. And we also are active in Interpol's environmental crimes working groups, and the chief of our environmental crimes section is recently elected to their environmental crimes executive committee. So we share information with them on the training programs we do and what they've done, and we have actually participated in some of their trainings. So they're also very active in this area. And we've also been in the recent past and over time in the past cooperated with NGOs such as the Environmental Law Institute on doing capacity building work. One of my colleagues who's here today just got back in the early December from a training program in Liberia for their forestry ministry on environmental compliance and enforcement. So we try to partner with entities such as that are doing effective capacity building on the enforcement area on these natural resource issues. And then another interesting development is we are now collaborating with other governments that have demand-side laws similar to the Lacey Act to work with them on both sharing information on enforcement in the natural resource areas and also working with them on capacity building. The Lacey Act, if many of you may know, but maybe not all of you, is a law that allows the United States to prosecute persons who trade in illegally harvested fish, wildlife, and plants taken in violation of foreign laws. So if a tree is illegally harvested in Indonesia and wood products are exported to the United States, it's illegal for those illegally derived wood products to enter the U.S. And that has been a longstanding law in the United States on the fish and wildlife side. It was expanded in 2008 on the plant side so that to better address illegal logging and trade in illegal forest products. And after the United States amended the Lacey Act in 2008, the European Union enacted the European Union Timber Regulations a couple of years later, which have a similar prohibition on trading in illegally derived wood products taken from illegal logging. And then the Australians followed up a year later with a similar legislation. So we have received support, vital support from NGOs such as Forest Trends and Chatham House to allow us to meet with our enforcement counterparts from the European Union on a biannual basis to talk about, share information on illegal wood flows, and also to talk about how we can work together. When we do our training in Cameroon in later this year, we're going to include the enforcement officials from the United Kingdom who enforce the EU timber regulations to take part in the training and have them share information about the fact that it's illegal to not only send wood to the United States but also to the European Union. So this is another area where I think there's been increasing collaboration and sharing of information among enforcement officials on the demand side, which is has been increasingly important and I think is a source for future collaborative work that could be expanded on. So kind of in sum, I think it's important that agencies work together to be able to develop training programs which are able to address the needs of other countries in the various aspects of the management and enforcement with respect to natural resources. And we are increasingly doing that with our investigative agency partners. And we are increasingly doing it with the U.S. Agency for International Development as a partner, which has just vital information, and we're delighted the fact that we've actually started interacting more effectively with USAID as a partner on this capacity building work. So this is an area where I think agencies are really beginning to work together, and I think there's a lot of hope for future collaboration among agencies on this work.
Very good. Thanks so much, Tom. I want to ask the first question. It follows a little bit on what Daniel was talking about, and it also takes into account the discussion on the first panel. So in many ways, it might have been better directed towards them, but it's coming to you anyway. And the issue really is, as we've discussed the notion of rule of law and the needs for transparency, accountability, public access, and so forth. And when we've paired that with the resource issue, what came through particularly in Daniel, but also in some of the other talks today, is just how long this takes. That this is really a long-term problem that deals with such issues as customary law that can go back hundreds of years, and how national laws conflict with customary law, and what sort of dynamics take place at that process. So since you all either work for the government or used to work for the government, the question is, when we approach rule of law and environmental issues, to what extent do agencies feel the need for a quick fix, or to what extent do they take a long-term perspective, that law actually moves very slowly, and that the changes we want to encourage will not take place probably in years, but in decades? So to what extent, as your agencies discuss these issues, deal with these issues, to what extent do you bring a long-term perspective in terms of how the rule of law can impact environmental issues? Or to what extent are you responding to short-term needs that have to be addressed? That's a big question, I realize. So I'll throw it open to anyone who wants to take a shot at it.
I'll go first. I can say this now that I'm retired and no longer there. in an organization, but my current organization takes a very long-term view of things. Our current project is to establish a global enforcement system within the next 10 years. So we're looking at a 5 to 10 year process to do exactly that, recognizing that things take time, that when you do things quickly, when you're driven by timelines based upon somebody's tour of duty or on somebody's tenure in office, it tends to be short-sighted, and many of the nations I've dealt with in the past have been a victim of that, where we as a government have gone in, applied a solution that is short-term, not followed through with it, and to come back to the next year or two and find it, all the work that had happened previous to that, gone, and starting over again. So to answer your question, I would hope that most agencies that are in it for the long term are looking at the long view perspective, recognizing that sometimes it's painful, it takes a long time, but if you're in it for the long haul, you will see results, as most of us have been in it for a long time, have seen over the years.
I think I see it, and the other attorneys in our office see it as a long-term effort, that getting effective environmental governance on these these resource issues in other countries is not going to be a simple thing. That just one example, we've been doing training for a few years in Brazil, and some of the challenges that you see from the people who come to our training are really astounding. The Amazonas state, which I think is larger than, it might be larger than France and Spain combined. And the environmental prosecutor who came, a young man, said he was the only person who did only environmental prosecution for the whole state of Amazonas. And he covered all environmental crimes. And there was hope for them to have that Brazil would be able to hire about 600 new environmental investigators in the next year, but with the falling commodities prices, that their government is doing severe cutbacks, and so that's been pushed back for several years. So that it's going to the meeting the needs, the infrastructure needs for good environmental governance, I think is going to take a long time. But one thing that can be really effective is to get some very excited prosecutors as a result of our training who bring a couple of cases, who actually bring an effective enforcement case that gets some publicity. That can have some deterrent effect. So you hope for some of those quick outcomes from your training, but realize that for a real, true, effective governance, it's going to take a long time.
Sure, so I'll add something quickly. So actually, as Tom was saying, I think that it seems as though we are making faster progress in the wildlife trafficking area, where we're able to get a country like Kenya to actually up the punishment for smuggling items, and actually when you find that some people are actually prosecuted and punished in accordance with those new rules. And USA has been training judges and other people who help administer the law in the DRC and other Central African countries to actually enforce the law, and one hopes that the change that results will maybe be commensurate with the urgency of the wildlife trafficking matter. And that's one area where, being really patient maybe isn't the best strategy. I think, though, one challenge, though, is that especially with conservation issues, a lot of these things do happen over a long time. Then how do you measure whether you're making progress over a shorter time scale, right? Because you can't just assume that, it's a long-scale process. We haven't we haven't seen any change yet. That does give you information for sure as to whether or not things are going to improve in the long term or not. And so, at least, I'm an ecologist by training, and with some of our interventions involving local communities, one thing we're trying to do is in taking a step back and instead of trying to measure the whole population of, say, elephants in a forest where we're putting an intervention into place, maybe we can at least try and measure whether elephants are using the area next to a village or next to a community as much as they are in communities where the intervention isn't in place, right? So that's kind of a step. It's not the ideal, it's not the gold standard of evaluating whether something is happening, but if elephants are feeling safe enough to be close to villages where poaching seems to have been taking place in the past, then maybe that's an indication that even though it's a long haul, we're taking steps in the right direction. And I think from a scientific standpoint, that's a big challenge, finding ways to measure things in a shorter time span.
Open the floor to questions. Right here. We'll get you a microphone. I believe we have microphones coming. Right here.
Thank you very much. Those were really interesting presentations. My question really is to Swagel. Did I get it right?
Swigel.
Swigel. Right.
I got it wrong there.
Sorry about that. I get my name mispronounced all the time as well. So. But my question really is about the initiatives that you talk about in all of these countries that you partner with. Who is the driver for these initiatives? Do you find that there is synergy or link between who drives these initiatives and the outcomes that you get out of it? And also, are the outcomes that you get out of these initiatives similar across all sectors? In essence, I think what I'm trying to ask is, where you have certain sectors or industries that are sensitive to economic sensitive and others that aren't, do you find that there perhaps is a difference in how the enforcers are able to use or utilize the knowledge that has been gleaned from these training sessions that you have?
Thank you for that question. And who the drivers are it's kind of a mix. We for our work in Africa on wildlife trafficking, for example, the State Department Bureau of International Narcotics and Law Enforcement talked to us about doing this training and provided us with the funding for it. But this was an area where we do capacity building, where it's also in something that we have a desire to do, and it supports our work. Because we are prosecuting wildlife trafficking cases is a priority for the Environment Division. It is important for us to do this work, and so we were very happy to partner with State Department. But as far as the drivers from the countries where we're doing the capacity building, most importantly, we reach out to those countries and to the officials through our local embassies and ask whether they are interested in participating in this training, and so far we've found a great deal of interest from the countries in participating in the training, that they really do want to do work to address wildlife trafficking. It's part of their international commitment under CITES and under other agreements they've entered into, and it's also there's a recognition that it's a problem where their resources are being depleted, and financially they're being harmed by the loss of their resources. As far as whether there's a great I'm not sure on the last part whether countries are genuinely interested in doing the training, or whether it really, one of the problems in whether it's effectively sinks in afterwards is if the prosecutors and other investigative agencies who take part in the training have resources to actually carry out their investigative and prosecutorial work afterwards. So they can only go so far if they really don't have any resources. So in some of the countries, in South America, for example, where we do training, the investigative officials don't have cars. They don't have abilities they have to pay for their own gas or use their own car to get out to an investigation. They don't have communications equipment to be able to get back, and it can be very dangerous to go out and investigate these resource crimes out in the bush by yourself. So without the local resources to follow up and to actually do investigation and prosecution, it can be very difficult. Some countries are providing the resources to allow their officials to prosecute the cases, and others aren't.
Right here.
Hi, my name's Susan Lee, and I wanted to ask Mr. Schaefer, I know Pew's been involved a lot in Palau. I used to work as an environmental attorney there, and you mentioned the cost of enforcement. Going forward, now that they've established their marine protected area, I wondered if in your next 10 years of enforcement, issues at Pew, you're going to be able to focus on the challenges when you have that size a marine protected area and how you're going to enforce the limitations.
Palau is an interesting one because everyone seems to want a piece of Palau right now. China, Japan, U.S., Department of Defense, Department of Justice, not Justice, but Homeland Security. Everyone seems to want to do something in Palau as a model state to do these things. We've kind of taken a step back because of that, because there's a lot of conflict on who's going to do what and how they're going to do it and how it's going to be long-term sustained. But our engagement there is a longer term, and as we sit back and stay involved, but at the same time recognize that there's no one-size solution for everything. We helped them establish what they want to do, and now the role is for Palau to step forward their resources to show that they are in it for the long term themselves. That's part of the problem is when you provide support to any nation that wants it, is it sustainable? Is it going to result in something long term, or is it reliant upon donor funding to exist? And our goal is never to have something that's perpetually donor funded, but to stand on its own. So that's our next phase in Palau, is to get them standing up on their own. After we determine who it is that's done trialing and trying out different things in the region. Thank you.
Right here.
Hi. So my question is related to this ongoing discussion of short-term versus long-term, but it's for Dr. Saker. My mind hit on a small point that you made in your talk about how USAID trained and equipped forest guards, and I forget what country to which you were referring. I'm wondering if there, if there are mechanisms of sustainability in place for such a project like that. Or once the USAID retreats, do you expect the government to continue to invest in whatever country that was? I forgot.
No, sorry, I think you just said it was Central Africa, but a lot of the trainings happen in the DRC. I'm actually not sure about what mechanisms have been put in place for that particular program. So I think the hope is that the benefits that come from ecotourism and some of the other programs that are being put in place by USAID will ultimately mean that the incentives remain long term, even if USAID's foot isn't kind of in the room. But we also work through a lot of local partners, NGOs that have a long-term presence there, who hopefully would be able to maintain some pressure on the state to maintain their involvement.
I just want to follow up on kind of Daniel and Thomas's presentations, because they gave two very alternative ways of approaching the problem of resource and environmental crime. One was kind of peer pressure, kind of yellow cards and red cards, and the other is actual criminal prosecution. And I'm curious if both of you could either make a case for one over the other or how they work in combination. But it seems that both methods have been tried, and I'd be very interested to hear your impressions as to, from your experiences, which one kind of works better or why you favor one over the other.
Well, that depends on what you're trying to do, and every circumstance
enough,
it is.
yeah.
I believe they both have their roles and their position, and I think that enforcement in some respects and prosecution is much more palatable, particularly to the local level or anything that happens within the country. But when you're talking about influencing multinational countries or companies or people who are operating across transboundary areas, oftentimes the market incentive is more effective, because if it's too expensive to do it, they're not going to do it. They're driven by profit. You take away the profit, you take away the incentive, it doesn't happen. That's the goal. It doesn't always work that way, and you still need prosecution, you still need criminal offenses to really put a bite on some folks. But I think they work well together if they're done concurrently.
I think from our perspective, we have more the carrots than the ability to use a stick in terms of what the Department of Justice can offer. We can offer capacity building training and work collaboratively with them on future enforcement actions. But as kind of perceiving what the government can do on the other side, on the putting pressure on other countries. In the one example I can think of is in the trade sphere, that the environment chapters of some of the more recent trade agreements that the United States has entered into have had certain conditions that are imposed on in the environment chapter of trade agreements to require that other countries take certain steps before the agreement can enter into force. One example is there have been agreements, some of the recent agreements have required that the other country obtain CITES Tier 1 status, which means that they have all of the necessary laws to fully implement the CITES treaty under their own laws. And so the agreement can't enter into force until those countries take those steps. So and that is very effective because the treaty cannot enter into force and get all of the benefits of the free trade agreement. And that can bring about pretty quick change in a way that where many of these countries joined CITES 20 years ago, and they had never enacted the necessary laws, but then within 18 months of the signature of the trade agreement, they have enacted those laws. So that can be a quick incentive.
Right here.
Hi, my name is Carl Brook. I'm with the Environmental Law Institute. And I wanted to come back to a question, an issue that's a number of the panelists talked about, and that's how do you show impact? Some of it's due to the timeline, some of it's due to the many different actors. We so often have to show impact to get the money, to do the training, to do the project, whether it's standing something up and getting it going. But how do you show impact? Not the outputs, not what you did, but the longer term impact. This is something we've struggled with for a long time, and are starting to wonder if there might be a need to look at it a little differently when you have so many factors and different timelines, that maybe there's a different way of measuring impact than you do for more traditional boreholes and fence posts and things like that, which are more quantifiable. Wondering if there's a different way of showing impact than is usually done in development work.
That's always, as you said, is a difficult issue to deal with, because we, in our funding agreements with State Department, do have to talk what are going to be the measures of the effectiveness of the training program. So other than the output type things, the number of people who attend, well, that doesn't say whether they're going to prosecute any cases. We do include as measures increases in enforcement, but it's very difficult to measure across a whole country whether there is an uptick in enforcement on an illegal logging or wildlife trafficking cases. But another type of impact that we include is, and that's kind of unique to the mission of the Environment Division, is whether we have formed relationships and there's a sharing of information on illegal trade flows between our countries. And we do include that. And we have found that we are being provided with information that we are using in some investigations. We can't, and often we're kind of hamstrung because we don't talk about matters that are under investigation. So we cannot share any specific details with the State Department, but we do talk about some matters that we are able to talk about, that we are getting effective information on certain things. So that's one kind of measure that we have that's kind of unique to the fact that we do enforcement work.
Louise, we got a microphone to you right here.
Louise Shelley, George Mason University. When I was hearing about this illicit trade, there seemed to be two separate phenomena. One is the commercial fishing boats that are just engaged in illicit fishing, while some of the other types of activities against wildlife, like elephants and rhinos and others, are combined or intersect with other types of illicit flows. And do you have a strategy for dealing with these different types of crimes, where one is a standalone or when it converges with others?
So I know that when it comes to working with, for USAID's work on illegal wildlife trafficking, we do work with nonprofit groups that are both concerned with, say, human trafficking and other issues, as well as smuggling of ivory and rhino horn. I think one of the arguments we make is that the process of dealing with one of these issues helps us automatically deal with the other issues as well, and that builds that's a strong foundation for alliances with some of these groups, and routes the group or the project I mentioned at the end about reducing opportunities for unlawful trade in endangered species is one group in which we're working with the Freeland Foundation and other groups that are interested in those issues. I think that then for illegal fishing, where I mean, there are other alliances that you build, even if illegal fishing doesn't maybe. So, for instance, a lot of the people who work on some of these large international trawlers, some of them are actually indentured into servitude from a country like Indonesia. They're lured onto these ships, being told that they're going to get certain type of work, and then they're stuck on this vessel as they go abroad. So I think, first of all, the distinction, the separation of illegal fishing from other issues may not be as strong as one might think. But even, I think if you have issue areas that don't have as strong intersections with other illegal activities, then you just may have to have smaller alliances when you're dealing with them.
Well, I have one last question then before we break for lunch. I know we're getting very close to lunch, and this is primarily for Tom. You talked about really the strong collaboration you have from prosecutor to prosecutor, from state official down. I'm just curious, have you done similar training for advocacy groups from the bottom up? We haven't really talked about advocacy and local advocacy that much, other than Chris mentioned in the first panel that they seem to be rather good at what they do and can delay projects quite successfully. But in terms of how the U.S. government approaches this type of legal training, is it primarily focused on prosecutors and the state institutions, or do you also engage in training for local advocacy groups?
The Environment Division really focuses more of its training on the enforcement and also training for judges on environmental adjudication. But I know when we have worked with the Environmental Protection Agency, for example, on capacity building under some of the trade agreements where we're doing it on the pollution side, we have worked with EPA where there's more of a comprehensive capacity building program that we do in conjunction with EPA. So, for example, in the Central American countries under the Central American Free Trade Agreement, EPA had we worked with EPA's Environmental Appeals Bureau on training for judges on environmental adjudication and the unique issues that come up in handling the scientific and technical evidence that you have to deal with in environmental cases. But EPA also had other training programs. They had one for investigators on investigating crimes. They had an environmental impact assessment course. And they also did a training for environmental outreach and communications, so that their EPA's communications office did a training which does allow for that kind of transparency and sharing of information on environmental conditions to better enable the public to take part in environmental decision making. And then there was also EPA's Office of General Counsel did capacity building on helping with environmental laws and regulations. So the government as a whole does bring more than just enforcement training, and agencies, the policy agencies of the federal government, particularly EPA, do a broader range of training, which includes, I think, some outreach that does benefit NGOs and the local public.
Okay, well, I'd like to thank all our panelists for really just a very interesting presentation. I know all of you have been patiently waiting for lunch, and my one request is that you quietly and patiently go through the line, because there is a meeting taking place in the conference room right next to where you'll go online to get your food. So there'll be plenty of time to discuss once you get into the main cafeteria, but if you could quietly get your food, that would be very helpful. Thanks so much.
Thank you.
Thank you so much.
Thank you.